Where we're going to start is the Advanced Healthcare Directive, the most important document, I feel, out of all of them. This is where you share with your loved ones and give them instructions in making sometimes very difficult decisions. So under a Advanced Healthcare Directive or a power of attorney for healthcare, you designate an agent, and that's the person who's going to be making decisions on your behalf if you are no longer able. So what can they do? They decide what kind of treatment you get, who your doctor is, where you get placed, if you are going to have placement, and the big issues about life support and feeding tubes and respirators. Also, this is the document that this is the one power under this document continues after death, which is disposition of the person's remains. So as you can tell, choosing your agent is probably the most important thing. You need somebody who can keep a cool head in stressful situations, in emergency situations, can communicate your wishes, will adhere to your values, and do what you would have wanted, even if it's difficult for them to make that decision. So one of the things that people ask me is, my kids are out of state. Should I choose my out-of-state kids? Well, sure. But they're not going to be the ones rushing to the hospital in an emergency. Now, modernly, we can do a lot of stuff online, just like we're doing right now. You can communicate with the hospitals and doctors by text, but keep in mind that it's usually better to have boots on the ground if possible. So again, the thing I'm conveying to you is this is one of the most important documents, and do have conversations with your physicians. You know, how to structure the instructions to your agents so that your wishes are going to be managed or followed through with. So what kind of things do you have to consider in putting together your advanced healthcare? Well, we said already that you've got the most important decision is, who's it going to be? The next most important decision is, well, how to convey your treatment wishes to your agents. And so I've presented here some of the most important questions to discuss, both with your selected agent before you name them and with your physician, how best to ensure that your concerns are met. One time we passed around the 5 wishes cards, and that was so enlightening to me. So that's a really excellent tool to figure out what are the important things that your agents need to know when making healthcare decisions for you. I'll just give you an example. For me, I never realized until I pulled out that card from the deck, gosh, how important it was to me to be able to breathe easy if I was in distress. And that's something definitely that I want my agent to know, that under all circumstances, make sure that I am not short of breath. And my hair is combed. That's important to me too. All right, so you've signed powers of attorney for healthcare, also known as the Advanced Healthcare Directive. Then what do you do with it? Well, my advice to clients is scan it and then email it to your agents so that they have it electronically on their phone in case of emergency. They can just bring that right into the hospital. Back in the old days, I used to drive around with several copies of it in my glove compartment. For those of us who are old school, that's a good way of doing it also. But when we sign those documents, I always give a client a special copy to give to their physicians to make sure that it's always in the file. And I tell them also, if you've had a hospitalization, make sure that hospital has it on file as well. So one of the things that we are faced with is how to make medical decisions for those folks who we said, it's they do not have capacity to understand and sign these types of documents. Well, then you put yourself in a surrogate position, and your duty in that situation is to ask yourself, what would they have done in these circumstances if they had capacity? And that's why it is so essentially important to have these conversations ahead of time. Let's take a look at power of attorney for finances. All right, so we're now talking about the second document in our arsenal. This is the second most important document. Again, this is what we call planning for you during your lifetime if you became incapacitated. So the document that we want in California is known as the Durable Statutory Uniform Power of Attorney. So the word durable means that this is good for you even after you have become incapacitated. If it's not durable, it actually does expire on incapacity, as in only somebody else can stand in your shoes and conduct business on your behalf if you still have capacity. So this durable power of attorney means it endures even if you are incapacitated. So there's different kinds of powers of attorney. There's the immediate and there's the springing. So I explain the concept to the client and let the client decide. But what a springing power of attorney does is it only becomes effective if you become incapacitated. So, okay, yeah, why would you want anybody in your business if you had capacity to do things yourself? Well, the challenge with a springing power of attorney is, what if there is an emergency and something needs to be done financially immediately, like providing for care after an emergency, after a hospitalization? Well, nobody has authority to do anything until the power of attorney is triggered. And sometimes the trigger is a doctor's letter, sometimes it's 2 doctor's letters. And then the agent has the burden of running around town, getting doctor's letters, getting clearance from the bank to act as your power of attorney. That can be incredibly onerous. And so some clients who know that they are planning for illness or a diagnosis of dementia, they will often name somebody to act as their immediate power of attorney. Now, an immediate power of attorney doesn't stop you from doing anything you wish to do, but it names somebody who is empowered to act on your behalf if you want them to. Here's an example. I heard clients complaining about, oh, there was this weird charge on the credit card, and they wouldn't talk to my son. And so I explained, well, an immediate power of attorney can help that type of situation. Yes, you have a capacity. Yes, you can do things on your own. But who wants to sit on hold for an hour to talk to Fed American Express about a weird charge? So again, what happens if you don't have our power of attorney? This is our most common scenario under which we have to pursue conservatorship. Here's an example. A spouse, well, it was time for the required minimum distribution in his wife's IRA, and she could not communicate with the IRA company, and they would not communicate with him. And so he actually had to get a conservatorship in order just to ensure that the required minimum distribution was made on time. So the other thing that you need to know about the power of attorney is that it ends on death. I've certainly heard about folks trying to use a power of attorney at, say, Bank of America after the person died. And somehow Bank of America already knew, and I'm not exactly sure how this happens. I think the mortuary informs the Social Security, and then Social Security informs possibly the IRS, and then the banks know when somebody has passed away. But anyway, I'm just sharing that a power of attorney isn't enough. It's helpful, but it isn't enough because it ends upon a person's passing. But if you have any real property, if you have more than the amount that we said, 185,000, or if you want to think about pre-mortem planning, like we were talking about the power of attorney, like we were talking about the advanced healthcare directive, the living trust is a living document. This supports you during your lifetime as well. So what you are doing when you create a trust, a revocable living trust, is it's this basket that holds all your money and property, and you are the steward of that money and property for your own benefit. The trustor is the person who creates the trust. That's you. The trustee is the person who administers the trust. That's you. The beneficiary is the person who gets the beneficial ownership of the property in the trust. And when you create that trust during your lifetime, that's you. So there's no separation between you and your property in a revocable living trust. But the beauty of it is that, well, it can hold any type of property, such as real property, out-of-state property, bank accounts, investment accounts. But moreover, it gives instructions to a successor trustee to step into your shoes and manage all that money and property for you during your benefit should you become incapacitated. And it also ensures that you avoid, what did I say? $15,000 to probate an estate. It's real. Okay. So I had mentioned there's sort of three hats that you wear when you create a trust. You're the trustor, you're the trustee, and then you're the beneficiary. Someday, you might have somebody else step into your shoes and act as the successor trustee. After you've passed away, somebody else, whoever you've named, are going to be the beneficiaries. But always, always, you will be the creator. You will always be the trustor. So what do we think about when we're creating a revocable living trust? Well, the same thing that we have said before is you need to name an appropriate successor trustee. Because you have to think about all the possibilities in the world. Anything can happen to anybody. Now, one of the challenges that some families face is they say, well, we're a really small family. I don't have anybody. Some folks aren't married. Some folks don't have children. Or if they do have children, their children just are not available. What do we do then? Well, there's a wonderful industry that cropped up because of exactly that need. More and more of us, for whatever reason, don't have family to look to for support in these roles. So I'm often recommending for folks private professional trustees. These folks are licensed, they are bonded, and they know how to be trustees because that is the business that they are in. And, I'm asked, well, are they expensive? Mm, they charge fees, certainly. But what's interesting is they now all have to post their fees right on their websites. It's now the law. And they seem to be going for about anywhere from $100 to $200 per hour. And, if you did name a private professional fiduciary, say as one of your agents, or pardon me, successor trustees, they're not going to charge you unless and until they're actually acting as a agent or a successor trustee. So the other thing that we have to think about is what money and property goes in. I said anything can go into trust. However, don't forget, some of our assets are pay on death accounts, such as IRAs, annuities, and 401ks. So I just faced a very interesting situation where there was a revocable living trust. The home was in the trust, the bank accounts were in the trust, but there happened to be a really big life insurance policy not in trust. And the insurer cannot discern who the beneficiary was. Either the record got lost or something happened. And so we're faced with, what do we do? We knew that we did not have to probate because we have a revocable living trust. But that asset isn't an asset of the revocable living trust. So still, I got to get a court order to recognize that insurance policy as an asset of the trust in order that we don't have to probate it. So when doing an estate plan, I always tell clients, let's take a look at your IRAs, annuities, 401ks, anything with a beneficiary designation. And so you need to make sure that whatever that beneficiary designation says is going to align with what you've done in your trust. This is especially important for most of us because a lot of us are have a lot of our wealth in the IRAs, annuities, and 401k. So do recognize that only an individual can own an individual retirement account, and therefore it's not an asset of your trust estate. I had a client come in today to pick up her estate planning binder, and she asked me, well, what do I show the bank? She has this nice binder and all of these tabs. What do I show the bank? And because she understood that now that she has a trust, she has to go on down to that bank and tell them to title her trust, her bank account in the name of her trust. Otherwise, it is not covered by her trust. And so I showed her, well, you show them this trust certificate. So that's what you all are assigned to do. If you have trust and you haven't done it already, is take your trust certificate on down to your bank and make sure it's titled in the name of your trust. So a lot of us did our planning way back in, say, 20 years ago, around the year 2000. And one of the things that I am finding from those trusts years and years old is that they are really complicated because of the tax laws back in the day. Estate plans, or pardon me, estates worth more than I think it was $1 million were subject to federal estate taxes. And so in order to avoid the tax burden, these old trusts say split the trust into trust A and trust B. And that is administratively a nightmare because that means your house has to be titled in trust A and trust B. The bank accounts, you have to open 2 bank accounts in trust A and trust B. And then do 2 tax returns. This would happen after the death of the first spouse. And then the survivor was burdened with the loss and then having to do all these administrative expensive things to avoid estate taxes. The good news is nowadays, the estate taxes exemption amount is now over 12 million for an individual, and then I think it's 23 million for a married couple. And let me tell you, I don't really know anybody who has this problem anymore. I hope this problem for all of you, but as of right now, most of us don't have to worry about estate taxes. Therefore, these old trusts were built for that tax environment, and we can do a lot better nowadays. What I recommend for most couples is something that I call the tax disclaimer trust. And it says, yeah, if the tax law changes and we have to split our estate at the death of the first spouse, yeah, go ahead. But if you don't have to, then don't. So it is my recommendation. If you have an older trust from back in the day, please do take it to an attorney just to review. Is it still functioning at this point? And you've got to make sure that, well, are the agents still available and appropriate? Are the beneficiaries still appropriate? And what were we talking about earlier? One of the big topics we got to get to next is planning for care. And so often I'm so disappointed when the family comes to me with an old trust and they say we got to do some Medi-Cal planning, and the power of attorney doesn't allow any gifting or transfers, and the trust doesn't allow any gifting or transfers. And I say, I'm so sorry. We have no authority to do anything unless it specifically says in the estate plan documents we can gift, transfer, change title, or do whatever. So I definitely recommend, if these are considerations for you, to look for your Medi-Cal planning clauses in your trust and your power of attorney.